Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Welcome to the last lecture video for the debtor-creditor in bankruptcy law. We're going to cover adversary proceedings, contested matters, and appeals in bankruptcy law. So we've done that in piecemeal throughout the lectures here and there. But as I was preparing those lectures and recording them, I thought, yeah, you know what? I think it would really help to put this into some, in one package, one little container. And by the way, it is 3:12 p.m. on Wednesday, July 16th. It also happens to be the time of day where my dogs get a little bit difficult to live with. They want me to be finished. And you know what? I want to be finished. I've been working on this course on bankruptcy for like 7 days straight. And as I said in the last lecture, I am feeling the pain. I'm tired. And so I agree with Max if you hear him in the background. So anyway. We're going to explore the essential components of bankruptcy law, but we're going to focus this time on adversary proceedings, contested matters, and the appeals process. We'll examine their definitions, structures, key features, along with the pivotal role that you play as paralegals. So we're going to look at an overview of adversary, contested, appeals. We're going to look at a comparative analysis of adversary, contested matters, and appeals. We're going to got a couple of knowledge checks at the end. And as of today, there is no quiz on this lecture. Future groups might, but so do pay attention if you're listening to this recording and you hear those words. But here we go. So adversary proceedings are found primarily in bankruptcy cases, and they resemble standard civil lawsuits with formal complaint and summons. And some common examples include objections to discharge, determination of dischargeability, or fraud claims. They're governed by the federal rules of bankruptcy procedure. Adversary proceedings have the structure of formal litigation with bankruptcy cases, and they're akin to a full-blown lawsuit. Key procedures are that initiated by filing a complaint, and it involves discovery, motions, and trial procedure. Some examples are fraudulent transfer claims, objections to discharge, and challenges to dischargeability of specific debts. They're governed also by the federal rules of bankruptcy procedure, specifically Part 7. Here are examples of the types of adversary proceedings, and these are related to proceedings to recover money or property. So preferential transfer, here's a definition of what that means, and the statutes that you might apply, that would be applied to this type of situation. This is definitely a great study tool if you want to dig in deeper on your own. Also, for proceedings to recover money or property, we have fraudulent transfers, and these are where the debtor either intends to hinder, delay, or defraud creditors, or receives less than reasonably equivalent value in exchange for the transfer, and either was insolvent, engaged in a business which retained an unreasonably small capital, or intended to believe that they were incurring debts beyond the ability to pay as they matured. Turnover is another form of adversary proceeding for recovering money or property when the debtor or trustee can seek a turnover any property belongs to the state, of any property that belongs to the state, or when a lien on the state property is imperfect toward the trustee. So the trustee determines a lien or other interest has priority over the trustee. And so think of the trustee. This is an important term that I've forgotten to bring up in the lectures. I started to, and I forgot the term. It's called the super creditor. So your trustee is at the tippy top. Your trustee is the super creditor, and they want that. And they want to keep that place. So this is an example of an adversary proceeding turnover that can help maintain that super creditor status. You have to file a complaint to avoid a lien within 2 years after the court orders relief, or within 1 year after the first trustee is appointed or elected. The case is closed, or the case is closed or dismissed, whichever is earlier. So the lien holder is the defendant, and here are the statutes. So the types of adversary proceedings also include, these are not to recover money or property. Revoking a plan, a confirmation order. A party in interest believes that the order confirming a plan in a Chapter 11, 12, or 13 case was procured through fraud. An adversary proceeding can be commenced within 180 days of the entry of the confirmation order. Another type of adversary proceeding is to determine a claim or cause of action removed to the bankruptcy court. So if during the case the debtor is engaged in another lawsuit that could affect the estate, such as breach of contract action, a party would prefer to try that lawsuit in the bankruptcy court, and then would go through a removal procedure, and that would be governed by those statutes listed. Now we're going to look at contested matters. So they're less formal than adversary proceedings. They arise from disputes in bankruptcy that don't require a full adversary proceeding, typically resolved through motions and hearings, and these examples include objections to claims or requests for relief from stay. To bring a contested matter before the bankruptcy court, parties need to follow specific procedures. And first, they file a motion outlining the dispute and the desired outcome. Next, they serve the motion to all involved parties, ensuring proper notice. And finally, a hearing is scheduled where they present evidence and arguments, and the judge makes a final ruling. Structure of contested matters. They're informal disputes, again, resolved through motion practice, and typically initiated by motion, not a complaint like an adversary. The discovery is limited and streamlined, and the procedures are quite streamlined. Some common examples of this are objections to claims, motions to lift automatic stay, requests for post-confirmation plan modifications, and it's governed by Rule 9014 of the Federal Rules of Bankruptcy Procedure. A motion to dismiss or convert in bankruptcy allows a party to request the court to dismiss the case or convert it to another chapter. And typically this dismissal is sought when there is bad faith, fraud, or abuse. Conversion may be requested to move from Chapter 7 to Chapter 13 or vice versa, and that would depend on the debtor's situation and eligibility. So requesting cash collateral, don't forget cash collateral. We covered that in a previous lecture, and that's where we're dealing with, so we'll go ahead and get our little handy dandy list out. Collateral for a loan that is cash or an equivalent of cash. A debtor is not allowed to use cash collateral except by consent of a secured creditor or an order of the bankruptcy court. So that would be the purpose, getting an order from the court. So to obtain financing in bankruptcy, first file a motion with the bankruptcy court seeking authorization to use cash collateral. Provide a detailed justification, including the budget and financial projections, and notify affected creditors and stakeholders, and allowing them to review and object. So the court will hold a hearing then and consider the arguments and evidence before making a decision. So automatic stay in bankruptcy that halts the actions by creditors when a bankruptcy case is filed and prevents collection efforts, lawsuits, and foreclosures. Creditors can file motions to lift the stay, and this happens a lot, allowing them to pursue their claims. Courts evaluate these motions based on factors like debtors' equity in the property and necessity for reorganization. So it's a motion for relief from stay. In Chapter 11 and 13 bankruptcy, that's a mistake. No, sorry, in Chapter 12 and 13 bankruptcy, an automatic stay halts actions by creditors against co-debtors. So this is common. Relief from this stay can be granted if the creditor can, because in 12 and 13 are the only chapters that have co-debtor stay. So the co-debtor of a debt may not be one filing the bankruptcy. For example, if the co-debtor is not the spouse of a person, and that person files bankruptcy, their co-debtor would be subject to, the debt would be stayed from execution by the creditors until they seek and receive relief from stay. That makes sense, I hope. For Chapter 13, co-debtors receive protection if the debt is consumer-related, by the way, while in Chapter 12, the focus is on different debts and restructuring. To object to a motion for relief from automatic stay in bankruptcy, write a written objection in the bankruptcy court stating the legal and factual grounds for the objection, and attend a scheduled hearing to present evidence and argue against the motion and make sure all the documents and arguments comply with local bankruptcy rules and procedures. Here are other types of motions. A motion for violation of automatic stay. So if some creditor violates the automatic stay, continues to collect even though they should know better, then that would be a motion that would go into the bankruptcy court. Motion to use, sell, or lease. This is where the debtor in possession would file this type of motion in order to get court approval to use, sell, or lease property not ordinarily used in business. It has to be approved. Motion to assume or reject executory contracts. The debtor or the trustee may move to eliminate, reject, or reject certain contracts that are burdensome to the estate. Motion demanding turnover of estate property. Persons holding property of the estate have a duty to turn it over to a debtor or trustee. It could be money due and owing, or the debtor's books and records. Objections to claims. A creditor may file a proof of claim, POC, and assert a right to payment or an equitable remedy. The POC is prima facie evidence of the validity and amount of the claim unless the debtor or trustee objects. So obviously that's the type of motion a debtor or a creditor would file. Objections to exemptions. Exempt property such as home, vehicle, clothing, furniture is not subject to creditor's claims. Debtor claims exemptions in the schedules at the outset of the filing, but an improper election of exemptions or undervalued property or improperly described property could be subject to an objection by the creditor or a trustee. Motion for bankruptcy rule 2004 examination. There's insufficient time at the 341 meeting, for example, to question the debtor, or the trustee requires additional information that they want under oath. The court can approve such an examination of the debtor and others, so it's not just subject to the debtor. It does provide, it's kind of like, if you think about it, it's like a deposition. It provides a transcript and oath and that kind of thing. Not necessarily a deposition, but it is a lot like one. Applications for compensation. Attorney compensation must be approved by the court, and other people such as a trustee, examiner, accountant, or expert may also need to file an application. So that's it. Now you know a little bit about everything. And congratulations, you have finished. I have finished. I'm going to go take a nap. Take care. Be well, and good luck on the test. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.